Hello everybody, good evening. Welcome to JAIIB CAB English Medium channel. I hope all of you are doing fine. Today in this particular session, we will be talking about principles and practices of banking. Now, as you know that the examination is round the corner. It is scheduled in May, but the time with which we have to prepare, within which we have to prepare, it is much lesser as compared to the time when it was before registration. So, since the registration will also be ending on 22nd of Feb, now is the time to have a dedicated preparation. You cannot just have a lax-sided approach that yes, we can crack this exam just by preparing for 1 week, 2 week or a month or so. No, try to brush up your concepts, try to have a comprehensive preparation for all the important topics, at least if you have not prepared till now. Okay, so today we'll be learning about the different modes of charging securities. As you know that we are covering your module B in PPB, and here in module B we have seen in the last lecture that what all types of securities are there. Various types of securities we have seen. But when we come to the implementation part, fine, how they are being implemented in our country, or for that matter implemented in our banking system, that will be defined via the different modes of charging the securities. How you will be charging, how you can claim, or under which act, which law you can claim that yes, this particular security is apt for recovery, or for that matter this particular security falls under the specific loan agreement. All these things we'll be learning in your different modes of charging the securities. And one important point here is that you must focus on some specific areas. Not all areas are that important, but yes, certain specific areas you must lay emphasis on. First and the foremost would be simple meaning and essentials of the contract. This is very important, because in the actual examination of PPB you will find the definition based questions. Fine, although everyone knows that what do we mean by a contract, or for that matter how it is different from the agreement, but still you must know the exact definition, the verbatim definition, because they ask the same definition time and again in the PPB exam. Then comes the types of contract. You will be learning about the contract, the meaning, the essentials of the contract. We will be defining the contract. And after that, there will be two types of contract, which most of you have covered in module A. Remember, the first chapter of module A is what? It is the banker-customer relationship. And in this banker-customer relationship, we have seen various types of relations. One was the relation of principal and agent. Fine, so the bank will be working as the agent of the customer, trying to provide certain services, trying to have certain funds remitted on behalf of their customer. Fine, so acting as the agent, and the customer will be the principal. So what kind of contract is involved in such relationship, such banker customer relationship, we'll be learning in contract of agency. Now one more important point here in this chapter of your unit number 26, basically you will find that there are various acts. Okay, so these acts you should learn, no harm in learning the acts, but ultimately you must lay more emphasis on the exact keywords which are written in the definition part of these acts. Fine, so agency, agent principal relationship, as you know the basics already, we will be capitalizing on the basic and trying to define that what exactly this contract looks like. After that, we have the contract of bailment. So bailey-bailer relationship, again very important relation which we have seen in the banker-customer relationship chapter only. So what kind of contract is there when we talk about the bailey-bailer relationship? The contract of bailment. And do not think that it is a very simple concept, that yes, like in your module A we have studied already, so it will be a cakewalk. No, not at all. You have to have good discussion around these two types of contract. Question will be asked from here. Next comes the types of charges. Now ideally most of the questions should revolve around these topics, but we have seen that only 0.5 marker question, or for that matter at max 1 marker questions are being asked from these types of charges. But again, we won't be ignoring these topics, but at the same time we should not spend so much of time reading one by one every line whatever is written in this particular types of charges. So starting with assignment, what is lien, set off, right of appropriation we'll be looking into. Hypothecation, pledge and mortgage. I hope that in the last lecture when we have studied the types of charges via examples, you are now able to decipher, able to give me the answers that for hypothecation what is the ideal type of loan. For hypothecation we see where the property is involved. So home loan, mostly you will see the hypothecation, not home loan, it will be what? Your car loan. Yes, just a moment. It will be what? The car loan, hypothecation of the vehicle which is involved. So for hypothecation it will be the car loan hypothecation. Next, what is the another type of loan where hypothecation is there? So we have the hypothecation of crops also. In KCC you will find that we are doing what? Hypothecation of the crops, because they are what? They are movable. When we talk about immovable securities, immovable instruments involved, so we will be doing the concept of mortgage. So mortgage, home loan or the property, whatever is involved here, we will be fulfilling the type of charge as mortgage. Then we have pledge. All of us know it talks about one important loan type which is gold loan. Fine. So gold loan here, your pledge. So all these important types of charges we will be revisiting again. Then comes the registration of charges. What is a charge and how it is registered with the ROC, Registrar of Companies. That is a process which you must know. From here also questions will be asked. So more or less you can expect the questions, maximum questions from the contract of agency, contract of bailment and the registration of charges with ROC. Fine. These three are the most important topics from where the questions will be asked. Now let's try to define the simple contract. Fine. Whether we can have the type of setup with any type of security, any type of instrument or not, or whether there is some specific items mentioned in the Indian Contract Act. So all of you must be knowing that we talk about the Indian Contract Act 1872 whenever there is a discussion around the contract. And here you will find that mainly contains several provisions for creating a lender's charge on most of the assets as security for the credit facility extended to the borrower. So in case you have missed the previous lecture, there also we have seen that the bank, or for that matter your lender, will be securing its assets. Fine. In order to secure its asset in the form of money which the lender has lent to the customer, they will be doing what? They will be charging some type of security. Mostly you will find primary security is there, but sometimes collaterals will also be involved. Another law that contains important provisions of the creation of this charge, especially on immovable properties, is the Transfer of Property Act 1882. So whenever we talk about the immovable property, it is having some rules, some guidelines in the Transfer of Property Act, that is your 1882. So very important act. We will be learning about this in the upcoming chapters also, when we will be doing the home loan. There also we will be studying the Transfer of Property Act 1882. Charges are required to be registered as per the provisions in various laws. Companies Act, we have Registration Act as well as Surface Act. All of these clubbed together, one question can be asked, but most importantly you must remember all the stipulations mentioned in the Surface Act along with the SURSAI. So in the upcoming chapters, this topic, the Surface Act of 2002, we will be covering it in depth, because from here also questions will be asked. More or less when we talk about the introduction, it just says or states that what all acts are involved, what all legislations are involved in respect to your contracts. So what is the meaning of contract? Let's see one by one. So whenever we are trying to define any kind of process, we must go with example, and we have done the same thing in the past lectures also. So first of all, we will be understanding what specifically is mentioned in the Indian Contract Act, and then via one example also we will be learning the entire process. So it only means that an agreement which is enforceable by law. Okay. So Mr. X has agreed that if his son is able to secure 90%, not 100%, 90% marks in this year's board examination, then Mr. or Mrs. X will gift their son or daughter uh, a particular car, right? A particular car which he or she will be able to drive only after the age of 21. Okay, so this is what, this is just a verbal agreement. They have reached to a consensus verbally only. But if let's suppose Y is able to secure 95% and Y approaches X with the demand of a supercar, can X refuse to it? Answer is yes, very easily. Okay, so this is what? This is the example of a verbal agreement, only the agreement. On the flip side, when we say that certain rules, regulations are there in various companies in the form of incentives, and that incentive is directly linked to the agreement. You will be signing an agreement with your employer X, you are Y, the employee, and the incentive is directly mentioned in the contract. You always say na, that a contract has been signed between the employee and the employer. So that particular contract, in case of this car only, supposingly X, the employer, has said that if you work really hard and give me 100% profit in the particular financial year, I will be, or the company will be, gifting you a supercar. Okay. So that is what? A contract which is enforceable by law. Tomorrow, if X refuses, Y can approach the court. Okay. So that is the thin line of difference between a contract and an agreement. Both starts with the basic terms and conditions, and a consensus will be reached by the parties involved. But whether that particular consensus which they have reached, which they have finalized, it can be enforceable by a law or not. If it can be enforceable by the law, then we are talking about the contract. If not, then it stays a simple agreement, right? So it has two major constituents. One is agreement between two persons or more, fine. Contract can be with n number of parties also. Okay, you cannot just say that I am a single person, a single individual having a contract with myself. No, it requires two people. The agreement must be enforceable by law, rights and obligations arising of it, which means it is made by free consent of all the parties. See, the consent is very important. When I said that both the parties have agreed to the terms and conditions, they have reached what? A consensus. Fine. Consensus has been reached by the two parties. So the consent is involved of both the parties, or whatever the number of parties are involved. It is made for a lawful consideration. It is backed by certain law. Law backing is there. Then also you will be able to say that yes, we are talking about a contract. All these things must be clubbed together, 1, 2, 3, 4, not individually, but we will be doing what? A comprehensive coverage of all these 4 pointers will lead to a contract. It is made with a lawful object. Certain guidelines are there in the legal parlance where you cannot have the enforceability for all the things whatever is ongoing. Fine, all the things whatever is ongoing, you cannot have the enforceability. So if you cannot enforce something, some object, or for that matter some process via a law, there is no lawful consideration, then you cannot say that we are entering into a contract. It is not declared as void expressly by the Indian Contract Act. So ICA has not given the terms and conditions where this particular agreement will be termed as null and void. So it must be enforceable by law, and along with that it should be there explicitly mentioned in the Indian Contract Act. Okay, there should not be any exception to what kind of agreement they are agreeing to. Fine. So simply stated, A contract simply is an agreement, but which will be enforced by the law. And these four, you can say pointers: consensus, lawful consideration, lawful objects consideration, in a better manner you can call it that, and no exception is there whatsoever when we are talking about a specific situation, right? Till here, if there is any doubt, you can just ask me. Let me just see the comment section also. Now comes the key components to form a contract. Whenever there is a contract, what all key components are involved? Because ultimately, if you do not know that what all parties are involved, what are the terms and conditions involved, you won't be able to make a valid contract. So, simply stated, a proposal becomes a promise when it is accepted. First of all, there will be a proposal. The process of making an agreement into contract starts with the proposal. So, you are proposing something. So, supposingly there is a person who is proposing something to the another person. So, whosoever is proposing this proposal will be termed as promisor, and the person who will be accepting this proposal will be the promisee. Okay, these are the terms which you must remember, because ultimately if case study based question is asked, they will be asking via these technical terms. So when one person signifies to the another person his willingness to do or not to do something with a view of obtaining the consent of that other person, he is said to make a proposal. So proposal can be accepted or it can be rejected as well. Right? There is no harm in rejecting a proposal. When a person to whom the proposal is made signifies his assent or the consent, the proposal is said to be accepted. Right? So whenever the promisee says that yes, I agree your proposal, the promisor's proposal, then this particular proposal will be deemed as accepted. So proposal and acceptance, there must be a lawful proposal by one party and the other party must accept the proposal. Fine. This is what it was written in the first point. It is made by free consent for consent of all the parties. So yes, when when a proposal is accepted, it becomes a promise. Thus, an agreement is an accepted proposal. So what we have just now done, we have just now given you the definition of agreement. Fine, because an agreement which is enforceable by law, it will be termed as what? Your contract. But what is agreement? It is an accepted proposal. Fine. So once the proposal is accepted by the promisee, this proposal will be termed as an agreement. Okay. So first step will be proposal, then comes the agreement. A proposal or offer is to be distinguished from the invitation to offer on the basis of intention of the person making it. So intention also matters. Fine. You cannot just say that a person is having malicious intent behind this particular proposal, and still we would be saying that yes, this proposal will be enforceable by law. No, it won't be enforceable by law. And when it is not enforceable by law, or for that matter lawful consideration cannot be made, then you will say what? That it is not a contract. Okay. Fine. So when we talk about the meaning and essential, that is the reason why I was telling you that all these 4 pointers should be agreed upon. Only then we will be saying that a particular agreement is a contract. Okay. So yes, it should be enforceable by law as well. You should not have a malicious intent, and if you are having a malefied intention, that particular proposal won't be enforceable via law and it won't be converted into a contract. Leave aside contract, not even an agreement. Okay, so A proposes by a letter to B to sell his car for, let's suppose, 10,000. That is just for the example. Now, if B accepts the proposal, then he becomes the promisee. Here, what B has done already, we are talking about a promisee only. So, this is known as what? This is known as a proposal only. A is the promiser and B will be the promisee. This results into a contract. Fine. Once it is being enforced by a law, if it can be enforceable by the law, it becomes a contract. So a letter asking for quotation of the goods and invitation to offer, when the quotation is being sent, offer is being made to buy the goods at the quoted price itself. In case the quotation is accepted by placing an order, a promise is being made to pay the price on the consideration that the seller would deliver the specified goods. So agreement will be arrived after all the terms and conditions, whenever the T and C's are properly defined. And one of the important T and C will be the delivery of goods. In most of the agreements, you will find that something is being offered to the another party. So delivery of goods, if it is being implemented, then we can say that yes, this particular proposal has become a valid agreement, and since it is enforceable by law, we are talking about the valid contract. So delivery of goods, if it is done or is intended to be done, we will term it as a valid contract. Now comes the agreement type. It can be oral also, as we were discussing about X and Y, right? And it can be written as well. So while valid contracts can be under oral agreements, under certain laws an agreement is required to be in writing only and is also required to be registered and attested. And this is what makes the banking agreement very, very important. Fine. Banking agreement, because we don't go by the verbal agreement. Fine. Letter of arrangement, agreement letter. Whenever there is a loan, we intend to have the signature of the customer via the banking agreement, fine, on paper itself, on the written terms and conditions itself. No type of oral arrangement is done. Whether it can be done, yes, it can be done, but in banking it is not. Consideration, there must be a lawful consideration for both the parties to enter into an agreement. Consideration means something in return. I will be providing you with the EMI when you will be giving me the entire loan amount. Okay, it's not that you are asking me for an EMI which is corresponding to 50 lakh rupees loan, and in turn you are only giving me what, 20 lakh rupees. Okay, this is not a valid agreement. Leave aside the contract. Okay, so that is how we start with the proposal. It is accepted, turns into agreement, enforceable by law. If yes, it will be termed as a contract. Next important essential of valid contract. Supposingly A agrees to sell her car to B, provided that B gives 1 lakh to A. Here A's promise to sell the car is consideration for B's promise to pay the money. You are offering something to the another person, and then only the another person is considering your request. It's not that you are giving something for free and the another person is happily admitting to that particular deal. So B's promise to pay the money is the consideration for A's promise to sell the car. These are lawful considerations, fine, backed by law, and the contract is enforceable by law. It has to be remembered that an agreement without consideration is void. Fine. If you don't have any type of consideration, there is no delivery of goods, or for that matter, payment of goods, payment of the services which you have offered is involved, it will be termed as null and void. Now, when we talk about some oral agreement or the agreement between the relatives, fine, supposingly father and son, Mr. A, out of his natural love and affection, promises to give to son B a sum of 1,000 rupees. A puts his promise in writing and registers it. Okay, normally it does not happen, but yes, just to give you an example, this will be a valid contract even though there is no consideration from B. Fine. So B is not at all having any type of consideration, no expectation whatsoever, no, you can say, expectation of some type of services is there, but still it will be a valid contract thanks to the validity which is offered by this particular agreement. Okay, so in rare scenarios, such type of agreements are also valid contract. Now comes the free consent, where it is defined. Okay, the process is very simple, which we have discussed till now, but where these are defined, in which section these are defined, under which act they are defined, it makes it very, very important. And this particular free consent has been asked multiple times by IIBF in PPB exam. So free consent of the parties to a contract is required. We have seen that contract is said to be free when the parties agree to the same thing in the same sense. Fine. Your interpretation is in sync with the another party's interpretation. Consent is said to be free when it is not caused by coercion. Fine. There is no loophole in the entire contract, in the entire proposal. As defined in section 15, or undue influence, that forcefully you are influencing something on the another party to have the contract signed. If there is no such thing, but it is defined under section 16. Fraud is defined under section 17. Misrepresentation defined in section 18. Mistake subject to the provisions of section 20, 21 and 22. So these section numbers and their description, it is very, very important. Mark this, very important. Fine. You must remember all these important sections and their description. Okay. Now comes the capacity to contract. Who can enter into a contract? A valid contract is the one where the agreement is done and is enforceable by law. The simple definition. The parties to an agreement must be legally competent to enter into a contract. So minor, no, not at all allowed. Section 11 of the Contract Act lays down every person is competent to enter into a contract if he has attained the age of majority, he is of sound mind, he is not disqualified from entering into contract by any law to which he is subject. Right. So whenever there are minors involved, you won't be able to have the capacity to contract. If you are not able to make your decision on your own, then also you won't be able to enter into a contract. Or for that matter, if you have been disqualified under any law, then also you won't be able to enter into a valid contract. Apart from that, apart from these three conditions, anything else, you will be able to have a valid contract. Now, mostly minors contract, it in news, or for that matter in courts also, we will find certain cases around the minor contract. So let's see which section defines it. So as per the section 11 only of the Indian Contract Act, minor is a person who has not attained the age of 18, irrespective whether the guardian is appointed by a court. So always remember, here in the Contracts Act, 18 years is the age for the minor. As per the law also, it is 18-year only. But when you talk about the banking operations, if you have attained the age of 10 years, you can operate. So do not mix or do not confuse these two ages when we talk about the minor's contract. An agreement made by the minor is void ab initio. Principle behind this is that minor is not supposed to have a mature judgment. By its own virtue, it will be null and void. Fine. By the inherent nature of this contract, minor's contract, it will be null and void. You need not to justify it. It is there ab initio. Okay. Now comes the contracts, the types of contracts, contract of agency and the bailment. Now we'll be learning about both of them. But till now, if you have any doubt, you can just ask me in the chat section as well. Okay. Okay. So contract of agency, first we will be learning that where they are defined. Fine. The contract is defined where. So agent and principal, the two parties of this particular contract, they are defined under section 182 of the Indian Contract Act 1872. And when we talk about how the agency can be terminated, who can terminate this particular type of setup. So the principal revoking his authority, directly the principal can move out. Agent is renouncing or giving up the business of the agency, that I cannot do your work, then also this will be null. Business of the agency being completed, that now I have done whatever you have assigned, whatever the job was, I have done that. Now the job is complete. Let's just terminate this particular contract. Either the principal or agent dying or becoming of unsound mind. Fine. So death as well as the incapacity to have or make the decisions. In both the scenarios, it will be termed as null. The principal being educated as an insolvent. If the principal is not at all having the money, how the agent will be working for that person? No, not at all possible. Okay. Now comes the contract of bailment, under which section 148 it is mentioned, and here it was 182. So both these sections also you must remember. So section 182 defined your contract of agency. 148 will be defining the bailment. It is just the delivery of goods by one person to another for some purpose. Can you tell me that under the bailee-bailer relationship, which we have seen in the module A, what is the prime example when we talk about the relationship between the bank and a customer? Quickly tell me in the chat section, or if you are watching this in the recorded format, tell me in the videos comment section. Upon a contract, they shall, when the purpose is accomplished, be returned or otherwise disposed of according to the directions of the person delivering them. So once the goods which are to be delivered, they are being delivered, and both the parties are having what they wanted, this particular contract is fulfilled. The person delivering the good will be the bailer, and the person to whom they are delivered is known as bailee. Okay. So what are the features? Let's see one by one. When we talk about the bailment features, disclosure to the bailee, who will be what? Bailee will be the person to whom the goods are being delivered. So disclosure to the bailer is bound to disclose to the bailee the faults in the goods bailed. Whatever you are giving to the bailer, you must disclose it upfront. Only then you will be able to have the enforcement, of which the bailer is aware. Fine, bailer must be aware that this is the fault, and that is the reason why I am telling the bailee, and which is materially interfere with the use of them. If some aspect of a good is not at all having the direct inference for the usage, not directly linked with the usage, then there is no need as such to tell. But if it is having a direct linkage to the operation of, let's suppose, this card, then you must tell the bailee, or expose the bailee to extraordinary risk also. What all risk is involved if you use my card? Okay. So all these things you must tell the bailee, you must disclose it to the bailee. Fine. Okay. And if he does not make such disclosure, he is responsible for the damage arising to the bailee directly from such faults. Okay. So the bailee will be able to have the questions answered by the bailer if something bad happens with this card, something which was not disclosed by your bailer. Okay. So supposingly A hires the carriage of B. There is A and this is B. Okay. So A is hiring the carriage or the cart of B. The carriage is unsafe, though B is not aware of it, and A is now injured. Fine. Supposingly this wheel, it just came off, and off-roading happened, ultimately injuring the person, that is A. And A is what? A is your bailee. B is responsible for this injury because this was the responsibility of B to give a particular cart which is up and running. No malfunctioning must be there. So now you can directly hold B as responsible for the injuries which have occurred to A. Okay, although it has not directly been inflicted by B, but ultimately if you are providing some service to A, then you are responsible. Okay, so when we talk about some more examples, supposingly A lends horse to B for his own riding only. Now after that, after A has lent the horse to B, right? This is B, supposingly in this case, this is A. And further, B is giving the horse to C. Now, if some malfunctioning happens to the horse cart, do you think that directly C can hold A as accountable? Fine. Although it was given primarily by A to B, but whether C can directly jump on the queue and say that yes, A is accountable. So B allows C, a member of his family, to ride the horse. C rides with care, but the horse accidentally falls and the horse is now injured. Okay, so the asset of A is now injured. B is liable to make a compensation to A for the injury done to the horse. Okay, so first and the foremost thing, directly C cannot hold A as accountable if just in case it was the fault of A's horse. But in this scenario, in this example, the fault is of C only. And who has provided the cart to C? B. So B will be held responsible for all the injury happened to the horse of A and will be compensating for the same. Okay, so that is how your bailment works. You need to take care of the goods. Mixing the goods expenses with the consent, there must be a consent that yes, we will be delivering these goods, I'll be delivering you a cart and I'll be responsible for these things. Mixing goods expenses without consent, possible to separate, but most of the time consent will be there. Without consent, not possible to separate. Again, both ways the contract might work. But mostly you will find that accountability will be of that party who is directly linked to the contract. Okay, not the further parties, not the other parties. Fine. Next is the duties of the bailee regarding the goods. There will be certain duties of the bailee also. So we will be covering the duties of the bailee along with the rights of the bailee in our paid classes, in our paid sessions. Till now, if you have any doubt, you can just ask me in the chat section or for that matter in the comment section as well. Okay, so we have done the basics of contract, how it is enforceable. Along with that, what all types of contracts are there and how in the banking parlance, in the banking industry, we tend to apply them. Now, if you want to have further discussion on this topic, you can directly contact me via this Telegram group. Okay, you can join the group via scanning this QR and there also you can have discussion. And for all of you who are preparing for IFS also, let me just tell you that on this group I keep on updating various recent government initiatives as well as RBI initiatives. So both of them will be updated on this group on regular basis. So if you want to stay updated regarding the economic developments also, then also you can join this particular group. And when you talk about the question, let's try to have one question solved here in this particular session itself. So with reference to the free consent, which is mentioned in the Indian Contract Act, consider the following statements. There are 4 statements. You just have to tell me which of the following are correct. Okay, try to answer this question because ultimately if you are studying without attempting the questions, it makes no sense. Since the time is less, always have this habit from wherever you are studying to have the concepts covered first and immediately after that try to solve the MCQs. That will give you a much better retention as compared to concepts only. So with reference to the free consent as per the Indian Contract Act, consider the following statements. Consent is said to be free when the parties agree to the same thing in the same sense. Yes, that's what we have seen. If a consent is obtained through undue influence as defined in section 16, the contract is considered valid but unenforceable. So that is the reason why I was telling that your specific sections and their descriptions you must remember, because IIBF will be testing you on these sections only, either by 0.5 marker one liner questions, or for that matter using one statement based on such description in the 1 or 2 marker questions. So whether undue influence is there present or defined in section 16 itself or in section 18, try to recall. Free consent is absent if the agreement is caused by coercion, fraud, misrepresentation or mistake. So whenever we talk about free consent, specifically, explicitly, what was mentioned, that it will be absent if the agreement is caused by fraud, misinterpretation, coercion or all of the above. The provisions regarding mistake, they are dealt with the section 20, 21, 22 of the Act. Again, specific sections you must remember and their description as well. What will be the right answer? Try to answer this question. 16, 20, 21, 22. After giving me the right answer, we'll be again going back to those sections also, because that is very, very important. So right answer is option B, 1, 3 and 4. Why second is not correct? If the consent is obtained through undue influence, we have studied that also, na? But whether it is defined in section 16 or not, whether it will be unenforceable or not, what are your views? Rest all is fine. In section 20, 21, 22, we talk about the provision of mistake. Okay, now let's go back and see that what all sections were there. Let's try to recall. So when we say that section 16, it is defined, it is defining the undue influence. Right? We are talking about the undue influence. And when we say that whether it is unenforceable or not, whether it is written or not here, for the free consent, there are 2 or 3 important sections. First one, whenever not caused by coercion, defined in section 15, undue influence, section 16, fraud, defined in section 17. These 3 are the most important ones. And here you can see for yourself, the statement says that free consent is absent if the consent is obtained through undue influence as defined in section 16, contract is considered as valid. Okay. Whether it will be valid or not, answer is no. Okay. So try to have all the keywords checked, only then try to answer the question, only then attempt the question. Otherwise, what will happen? Prima facie, it will look like the same line, the same statement which we have seen in the description, but ultimately the validity is at question. Okay, so the right answer will be option B, 1, 3 and 4 only. Fine. So yes, this was it for today's class. I hope that now you are in a position to know for yourself also that how the definition of contract works, what are the important types of contract, what are the important sections mentioned in the contract. So if you want to have all the syllabus covered from the Mahapack, or for that matter the recent batches which we have launched for JAIIB May 2026, then you can call us on the number which is your dedicated helpline 0981 981 9247. This is the dedicated helpline number for all the bankers. You can directly call us on this particular helpline. Okay, fine. And when we say that what is the discount code for maximum discounts, you can use the discount code Y1003. Let me just give you the number again. If it is not visible, let me just rewrite it again here. It is 0981 981 9247. Directly call on this number and all your queries related to the courses will be addressed. Fine. So this was it for today's class. See you guys in the next video. Till then, try to revise whatever we have studied and try to solve good number of questions based on the sections. All the best.